going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Wednesday. Hope you guys are all doing great. I've got some court. You guys want to watch some court? I want to watch some court. I'm not muted again. Legal fiction. I am not muted. I am not. Before we get started, Tommy V, thank you so much for the raid. I appreciate it. If one of my mods can please drop his link, that would be awesome. But yeah, go check out Tommy. Tommy has a great channel. Okay. Let's see. We have one civil matter before we get to the Judge Simpson clips, and the Judge Simpson clips they're good. They're good. Just a warning, they're good. All right. I think that's all I got to say right now. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
23-153-977. This is Midland Credit Management versus Daryl Rollins. The matter is before the court, set on for a hearing on a motion for summary disposition. Your appearance for the plaintiff, Midland, please.
Good morning, Your Honor. William Hill, P. 28608, appearing on behalf of Midland Creditors Coverage Council.
Thank you, counsel. Good morning to you. The court is looking for Daryl Rollins at this time. If you are present on this Zoom, please say something at this time, Mr. Rollins. Daryl Rollins. I don't see where he's on this Zoom. Counsel, have you had any occasion to have contact or speak with Mr. Rollins recently or anything, sir?
No, sir. We were last here on March, 28. Okay, we haven't had any correspondence from him that I'm showing in the file.
Thank you, counsel. In the court. Excuse me. The record should reflect that the court on that date, that is March 28, 2024, did set the motion for summary disposition on for hearing on today's date. The court generated a notice that went out on that date at the address provided by Mr. Rollins in his answer in response to the pleading on Leslie Street in the city of Detroit. I have not received any call or any indication.
Hey, Chris, good to see you. Also, I forgot to edit this first one out. The guy didn't show up. This isn't the case that we're here for. It's the one after this, but this one's quick. I apologize.
That Mr. Rollins was or is requesting an adjournment or anything along those lines. Matter set on for 9:30 a.m. Apple tells me that it's 9:59. Defendant has not appeared on the motion. I also note that I did not see a written response to the motion as well. Counsel, did you receive any written response to the motion?
No, Your Honor.
All right, given that the defendant has not appeared, has not responded to the motion in this matter, the court will grant a motion for a summary disposition, finding that there is no genuine issue of material fact, and that defendant is entitled to judgment in this matter as a matter of law. The defendant has not raised a legal defense to this matter, and the claim that is asserted before this court is established by the documents and affidavits presented to the court. Therefore, judgment will be granted upon the motion for summary, upon the granting of the motion for summary disposition. I do see that there is a proposed order, and the court will sign that order at this time on the granting of the motion for summary disposition. That order also contains the dollar amount for judgment requested in this matter, so forth. All right, thank you, counsel. Good day.
Thank you.
All right, do I need to restart? Do I need to say my intro again? What's going on? This is Colin. This is the case you're looking for. Come up right about meow.
We got a copy mail. All right, the court now calls.
All right, so just a little heads up. This is Judge Coleman, I believe. Judge Coleman. He's in the 36th district. You can tell all their courthouses kind of look very similar to each other. And he generally does civil cases and small claims matters. Yeah, I think that's right. I don't know if I haven't seen him do anything criminal in a while. Yeah, so I'm just gonna go with it. I could be wrong, but I think that's what. But yeah, he's Judge Coleman out of the 36th district. Let's go.
The court now calls case number 23, 241353. This is Alessandra Lavier versus Oakwood Car Center. Now, the matter is before the court on the filing of a motion to set aside the default judgment. The record should reflect that the judgment in this matter, or the, just one moment, I'm looking at the history here, that this case started in a small claims division, and that's why the court is taking a look at what occurred regarding this matter. Just one moment. The record should reflect that a demand for removal of this matter was filed with the court on the 2nd of January. Therefore, it was taken out of the small claims division and put on the general docket of this court. Subsequent to that time, there was an application for default, and all right, that seems like that's the history on this. So I set it up for hearing. Do I have Lavier on this Zoom? If you're here, say something at this time.
I had explained, I'm Carolyn Walls. I'm the other plaintiff on this. Alessandra's my daughter. She was called into the hospital. She's an ER nurse, and so I'm here. I'm the one that actually had paid for the car.
Yeah, but you're not a lawyer, are you?
No, I'm not. I'm one of the plaintiffs.
No, you're not a plaintiff on this case. I don't see your name on here anywhere.
It's at the lower part of your list.
Yeah, already. The Karen is strong with this one. It really is. Just wait. That's why this video is in here. This is a potential Karen. Let me know what you guys think by the end. But yeah, telling the judge, this is where my name is. I already know where it is on your docket.
I'm sorry.
She's on a different. She's under the one ending.
No, I think she's saying, no. I see it. Okay, all right. I see your name on here. That is correct, man. All right, so why isn't your daughter here on this matter as well?
She said she could come in, but she's an ER nurse, and they were short, and they called her into work at the hospital.
She don't have the right to not appear in court on that basis.
I can
Excuse me,
have.
You didn't interrupt me while I was talking. I know you did.
I'm sorry, there's a delay.
Yeah. Okay, so just hold up. I'll come back to you in just a moment. All right. Who are you? I see someone with Oakwood Car Center. Who are you, sir?
I am the owner of Oakwood Car Center, sir.
Yeah. Okay. I'll refer to you as owner then. What's your name?
Hassan Salame.
Okay. Say the last name again.
Salame.
Salami. Thank you, Mr. Salami, and good morning to you, sir. All right, Mr. Salami. I think this is your. I don't know who filed the motion to set the default aside. Was that you?
It was me, yes.
Yeah. So let me ask you, is Oakwood Car Center, is that a corporate entity, sir?
It's a LLC. It's a car dealership. It's a used car dealership, LLC.
Yeah, are you, yeah, I understand, but you're a limited liability corporation, is that correct, sir?
Correct.
Yeah, you're gonna have to be represented by counsel. In the state of Michigan, you have to, corporation has to be represented by an attorney. So you're gonna have to, get someone involved in this case, to respond, to this particular matter. I do see where there was something, removing this. Unfortunately, the file is somewhat confused because of the fact that it was in the small claims division, and then there was a removal that was filed on this matter. It looks like that removal was filed. There was an attorney involved in this case. So did you have an attorney at some point in this matter?
And I did not, but if we're talking about Miss Mosehim, attorney, she's my nephew actually, and I was just showing her what I'm going through, and she just guided me through it. But she told me I don't have to be represented on this, and I can do that myself. Therefore, I came down here. And I set aside the motion. I thought I was under the impression I'm just gonna get a court hearing and get it over with. And but I didn't know how the system works. I didn't know. That's my first time going through this, so this is all new to me.
All right, that's quite all right, but you can believe her or you can believe me. You can't, the company cannot be represented by you. It has to be an attorney involved because it's a corporation. Michigan corporation. No, just be quiet now. Listen, a corporation has to be represented by counsel, so we're going to set it up to give you that opportunity. And whoever signed this, of course, that person was a lawyer to get it removed to the to the general civil docket. But you're going to have to continue with the lawyer in order to go forward. I see the lawyer's P number on here, P5919, looks like 192. But in any case, whether you're going to use that lawyer or use another lawyer, you need to have someone involved in this because of the corporate entity. All right. So what I'm going to do is I will. There really is no basis for the entry of default in this matter where there was a removal to the general civil division. So I'm likely going to set that default aside, but I can't even address that today.
I'm sorry, I didn't get a chance to speak. Could I say something?
You can get a chance to speak when I give you a chance to speak. And I already told you once that while I'm talking, you're not going to talk while I'm talking. That's just not going to happen. It's not. Imagine what our court system would be like if judges allow people to overtalk them and talk while they talk.
I understand, but
you're not going to do that. You're just not going to do it. It's not going to happen. In a moment, I'm going to excuse you from the hearing. If you interrupt me one more time, I'm going to excuse you from the hearing, and it's going to be as if you were not here. So if you'll listen for a moment, then you'll begin to understand exactly what direction the court is going. But you're not going to interrupt me when I'm talking. You can't do that. So that, sir, with regard to the current.
Oh, she's not done. She's not done. And Skizrock's intro music's not finished. I want to stop playing it until they're finished because it's just a black screen. So I don't want to just keep playing a black screen. You know what? Screw it. Skizrock. Intro music uploading. Let's go. Where we go? I actually have a whole theme music folder now. Skizrock. Man, I just went to pause it. I just rewound it all the way to the beginning. Oh. All right, hold on. Let me
You're
find
limited liability corporation. Is that correct, sir?
Correct.
You're going to have to continue with the lawyer in order to go.
All right,
while
that's
I'm
just taking
talking,
out the head.
you're not going to talk while I'm talking. That's just
All right, I think we're good right here. All right, sorry everybody.
not going to happen. It's not. Imagine what our court system would be like if judges allow people to overtalk them and talk while they talk,
I understand, but
you're not going to do that. You're just not going to do it. It's not going to happen. In a moment, I'm going to excuse you from the hearing. If you interrupt me one more time, I'm going to excuse you from the hearing, and it's going to be as if you were not here. So if you'll listen for a moment, then you'll begin to understand exactly what direction the court is going. But you're not going to interrupt me when I'm talking. You can't do that. So that, sir, with regard to the Carson, you can't represent it. You've got to have a lawyer involved. Now, ma'am, I see that you are one of the plaintiffs on this matter. The motion that is filed in this matter refers to Ms. LeVere, who you've indicated to me is your daughter. It does not have both of you involved in this. But
Donald, man, you spent 5 minutes, talking up Judge Perkins's court coordinator. How dare you? How dare you? And this is a great pause screen, by the way, on Little Miss Karen in the top right. Again, like I said earlier, it's not finished. She goes on, and she does kind of drop the "Can I talk to your supervisor?" line in a different way. I don't know how you do that in court, but she kind of does it. All right, let's go.
I have the paper. If I could,
there you go again. There you go again. So you're talking and I'm not listening because you cannot talk while I'm talking. You can't do it. It's just not going to work. So because you keep interrupting me, I'll tell you what I'm going to do, and then I'll see you on the next occasion. And perhaps by then you will have come to the conclusion that you get to talk when I give you opportunity to talk, just like everyone else does. And I do that thousands of times, only over 32 years of being on the court. It's only in those rare instances where I have someone that feels like they have the right to talk while I'm talking. So, ma'am, what's going to happen here is that the case is going to be adjourned so that this gentleman for Oakwood Care Center can get a lawyer involved. If he doesn't get a lawyer involved in this case, then what's going to happen is a judgment by default, not just a default, a judgment by default is going to be entered, because it's going to be as if there is no one.
It'd be funny if someone did ask to talk to, Judge Coleman's boss. If she said this, like, I need to talk to your superior. Like, I'm not liking how you're doing your job. I need to talk to your superior. And then all of a sudden, Judge Bryant jumped on, and she was just like, "What?" I know she's not his superior. It would be the chief judge, right, Meconico? But that'd be really funny because Judge Bryant would put her in her place real quick.
Representing Oakwood. In regard to the motion, I am taking that under advisement. I'll make an ultimate decision on that. The likelihood is that I'm setting that motion aside, but I will also set it up so that parties can tell me what happened on both sides and the court can make a decision as to the outcome of this case. But we'll deal with that at the next hearing. So I'm going to set this matter over for May the 28th. That's going to be 5/28, and that's going to be at 9:30 a.m. And sir, you will have to have an attorney involved in this case, and that attorney will have to be present at the hearing at that time. And ma'am, if you can make sure that yourself and the other party is here on this matter, the other plaintiff in this matter, so that the court can address this matter with all of the parties involved in this case at this time. Now, I understand, I heard you say that you were a person that
Judge Perkins was awesome. He was awesome. It was kind of nerve-wracking when we first walked into his courtroom, but no, he was awesome. He talked to us in between, while he was waiting. It was a really good time. I highly recommend, if anyone's in that courthouse, just to go sit in his courthouse or his courtroom for 20, 30 minutes, just to have him talk to you, because it's a lot of fun.
were engaged in any business transaction. I still would need both plaintiffs here to prosecute this matter. And I will hear from both sides at the next action date. We'll see you on the 28th of May at 9:30 a.m. All right. And again, sir, you will have to get an attorney. If you don't get an attorney, I will be entering a default judgment against Oakwood Care Center. All right. Good day to both sides.
All right. You ready? You ready for Karen to speak out? It's a civil claim, so I'm not going to say it's about to go down, but it's about to go down.
Okay, I got a question, sir. It's Oakwood Car Center, not Care Center. And am I gonna receive something in the mail about the hearing on the 28th?
All right, yes, and pardon me calling it Care or Carson, whichever one it is. It's I have something here saying that it is Car Center, Oakwood Car Center. And yes, the notice is going to go out today regarding 5/28/24 at 9:30. But
Okay.
even if you don't receive a notice, you should receive a notice. But if you don't receive a notice, you know to be here, or an attorney has to be here on the 28th of May at 9:30 a.m. There has to be an attorney involved, right?
Okay.
All right.
Okay, and then use the same Zoom ID number and everything.
Absolutely. Everything
Okay.
is assigned to the Zoom. All right. Good day.
Okay.
Good day to both.
I'm
Ma'am,
sorry,
what
Your
do you
Honor. I'm sorry, Your Honor. You were breaking up.
Excuse me 1 second. Okay. I think I've already clarified the date that you have to be here. Ma'am, you were saying something. Go ahead, ma'am.
Yeah, I've tried. I am not in Michigan to start with, and there's a major delay between the computer. Okay, so I had no intention of cutting you off, but I had some things to say and I was never addressed. What judge are you, by the way? I did not get your name.
Oh, don't worry about that right now. Look on the paperwork and you'll find out.
Because I
what
thought
judge-
Judge Colin,
Listen to me. Listen to me very carefully. Both sides get an opportunity to speak on relevant issues. There is a motion to set aside a default. There was a default entered in this case. There is a transaction that occurred. That transaction that occurred transferred the case from the small claims to the general civil division. With that transfer, there is something, the bottom fell out somewhere because of that transfer. That's why the entry of the default is likely to be set aside. This has happened before. That does not affect whether or not the plaintiff actually has the rights that the plaintiff has asserted in this case. Whatever the plaintiff has sued for, the plaintiff will still have an opportunity to bring those issues before the court. I will evaluate those issues and make a decision as to the outcome of this case. So the case is now, it seems to me, the case is now finally getting on all fours where it should be. That's not your fault, Ms. Wall. It's not your fault that the case is positioned the way that it is. That had nothing to do with what you or your daughter did. Somebody filed a motion to remove it, and the case got stuck in the removal process. That's the thing I was trying to explain. You didn't do anything wrong on this, not at all. The case is, I have this case now, and so I'm going to move this case through the way that it should go through. And when there is the hearing on this, for the parties to tell their side and to tell what happened in the case, I'm going to shut up and listen to you. And the other young lady, whoever the plaintiffs are, I want to hear your side because I don't know what this case is about. I don't know the facts of the case. So I'm going to listen to you. I'm going to hear what you have to tell me. I'm going to look at whatever documents you have, and then I'm going to hear from the other side. I'm going to look at whatever documents they have, hear whatever they have to say about this case. And then I'll make a decision as to what the outcome is. Right now, we're dealing with procedural stuff. The final part of that procedure.
No, that attorney's not for either one of these parties. So the guy in the bottom right owns a car care center. He said earlier that it's like a used car lot. So I'm guessing he sold a car to this woman's daughter, and the ER nurse that's not here, but she co-signed for it, so she's on the whatever the summons as well. But no, the reason why this is being adjourned is because this guy doesn't have an attorney, and you can't represent yourself in a. He owns an LLC, so he can't represent himself. So they're adjourning it, and Karen wasn't happy about that, and she didn't like that she wasn't able to talk. But yeah, that attorney in the bottom left is not part of this case at all.
Piece is that Oakwood on the screen. The screen it says Care Center, and the file it says Car Center. That's where the confusion is. He's here, and it says Oakwood Care Center. The file says Oakwood Car Center. So that's why I was going back and forth between those two. Oakwood Car Center LLC cannot be represented by someone that's not a lawyer. He has to have a lawyer involved. If he brings a lawyer the next time, we get the case moving because there's a lawyer involved. If he doesn't bring a lawyer, then I'm going to default the case, not just a default, but a judgment gets entered, because there's no one here representing the other side. That's the status of the case at this point. On the 28th, I will see whether or not there is a lawyer involved. We'll address the underlying issues as best we can. That will not be the trial date, but I'm looking shortly after that time to actually set the trial date and hear the facts of the case to make a decision regarding the outcome. So I took a few moments to kind of go over this because I want all sides to understand where this is, because I know neither side are lawyers in this particular matter. But that's the way that this matter proceeds. Now, when it comes to talking about stuff, I know that there is a delay in the system, and I regret that. I know that's a part of technology. But the important thing is, if I'm talking, everybody has to wait. I'll give you a chance to say something. But if I'm talking, let me come back to you so that you get a chance to begin to tell me what you wish to tell me. There will never be a time that you'll come to court and it's the appropriate time for you to tell your story and you not get to tell your story. In 32 years that I've sat on this court, there's not one person that has come here on the day that it's time for you to tell your story that you'll not get to tell your story. It's not going to happen.
Look at her face. Look at her face. She is so disappointed right now. She's like, I don't believe you. I want to talk to your manager. I mean, if you could have, a stereotypical Karen look, her facial expression is that facial expression. I know there's whatever the hairstyle for Karen is, but I don't know. I think we need to rebrand it. I think she wins.
My personal integrity will not allow me to have you to come here and not be able to tell your side of the story. So that's going to happen. It's just not the day for both sides to tell me their side of the story, because we're dealing with procedural stuff. Okay. So I hope that gives a little bit more understanding. I look forward to seeing both of you on the 28th, and we'll address the issues that we can address at that time. If we can get it worked out, fine. If we can't get it worked out, then after the 28th of May, I will be setting a trial date on this. I'm going to set it as early as I can, so parties come in, lay out their evidence before me, and I'll make a decision regarding what the outcome of the case should be. Okay. All right, so good day to both of you. I wish you all the best.
Yeah, Your Honor, one more thing before you leave, please. It's Oakwood Car Center, not Care Center. Car Center.
Do you see you come up on the screen as Care Center?
You have complete control over what's on your Zoom screen, right? He's just reading off what it says on your screen. That's what's in the record. That's what he said in the record. The complaint says Car Center, but you have control over what's on your Zoom. Just go fix it, man. Just go fix it and get an attorney, because I want to see what happens with this.
Or was that something
that's where the confusion happened when they filed whatever they filed. So that's why I keep saying, trying to correct it. It's Car Center.
Yeah, the file has Car Center.
Okay.
So that's what matters. They sued the right people as Car Center. All right. I wish you all well. Good day.
All right. Thank you.
All right. I can't wait I really hope that they play the next segment of that on YouTube. I really do. I want to see. I really want to see. I want to see Karen. I want to see full Karen mode, because if there was an actual hearing, we would have got full Karen mode. I really believe we would have. All right. We're going to Judge Simpson now. I think I've got 2 hearings from Judge Simpson, and I think that's all. They're a little bit longer hearings. Yeah. I also just finished a really awesome bonus clip. If you guys are on your best behavior tonight, you're nice and well behaved, I'll treat you with a bonus clip at the end of the stream. But you got to be on your best behavior. That means like buttons. That's what that means. All right, let's go.
Court calls the case of People versus Manuel Henry. And there has been a motion. I've received a response. Is there anything additional? Go ahead.
Connor, I just believe that in this call, it's very important to look at all kind of pieces. It's really vivid for the by wrongdoing, and kind of look at separate parts. At the beginning of the call, it starts off with the defendant telling her that she wants her to not testify against him. And at the beginning of the call, the victim doesn't want that and wants him to be held accountable for his actions and says things like, I didn't want to do that, but what you did was really fucked up. He says, I want you to do one thing, there's only one way to be testified here, you need not testify against. She responds, you should have thought of that, but I didn't do anything, not that anybody would, cause anyone to do that. She's telling him she wants to be held accountable, she's scared of him, terrified of it, about what happened. And he keeps pushing, as the conversation continues, he keeps pushing the issue, telling her, tell them that you lied or something, this shit fucked up, this shit is fucked up for real, I gotta get back to my child. And he keeps pushing and pushing throughout the conversation and blaming her for the situation. And she keeps telling him she's terrified, she wants to be held accountable. She says things like, no, like I want to put a PPO on you because I'm scared to death. I don't know what you're going to do to retaliate. Keeps pushing her and saying, what you saying and this shit could have been fucking up my case right now. With that being said, I don't need you testifying against me in this shit. You do come, tell them what you were saying was a lie. And she eventually, throughout this call, begins to break down and is in tears and finally agrees to do something about it. Did, and blaming her for the situation, trying to make her feel guilty of the situation. And you can see throughout the call that he wrote her down to agree with his own opinion from the call and not come to court testify against her. It's just a very vivid portrayal in just one call of forcing her and breaking her down throughout the call, not testifying.
Ms. Gaines.
I would like to start with, and perhaps we can even approach and look at the file to see now has received service that the complainant has been served, or otherwise notified that there was in fact a hearing previously scheduled for a matter before it turned out that the person wasn't even aware or had not even been notified officially of the hearing. And so that's where I would like to start, because if there has been notice by people of this field, I think that immediately handles and immediately addresses this situation.
Our victim advocate did reach out to the victim about the.
Yeah, I don't know what happened to the audio in this courtroom. It went from decent to not so great, kind of overnight. And that's why I have the volume louder. I turned the volume up on my side. And now we're hearing a lot of feedback from Judge Simpson. It's kind of a tough battle. But this is a good case. It is. It's very interesting. And yeah, this defense attorney kind of gets you know what? I'm not gonna spoil it. Sparkle Poots, thanks for the 4 months. Thank you so much, Sparkle. That's awesome. 4 months. It's great. Thank you. Also, Sparkle Poots. So do I need to leave so others aren't punished for my behavior? Just checking. Nope. You don't got to go anywhere. Sit tight and enjoy the show, Sparkle. Thank you so much for your super chat and your membership milestone. You're awesome, Sparkle. Spookle Poots, Spookle Parts.
Assistant prosecuting attorney board of on the faculty. We don't evidence and they handle the rest of this, but I do want to note specifically there's a note in our file from victim advocate Spangler that she texted the victim on April 19th about the preliminary exam. It is also routine for our office to send a notice to the officer in charge to subpoena the victim. That I did send personally that notice to my officer in charge in this case, so the victim should have been was confirmed notified at least once that she was expected to attend to the preliminary exam. Contact was made and should have gotten an additional notification from law enforcement about that expectation. So I do believe our office has done our due diligence with ensuring that the victim was notified in this case.
So starting with that, Your Honor, I would state that I do not agree with that. indicates due diligence. To send a text message, it is not unusual for, without, there has been no indication of a confirmation of receipt of a text message. Without that, we don't know that it's still your phone number, if it's an error in the phone number, we do not know if that actually got to her. Second.
Well, why wouldn't that constitute due diligence? I mean, in light of the phone call, which has to be, quite frankly, in doing this for a bit, one of the most egregious of phone calls to a victim in the case. What if I follow your argument to its logical extreme? What would happen is the defendant or a defendant could make a call like that. The victim, out of fear, or alleged victim out of fear, could change her phone number. The prosecutor only has one way of contacting. And then, but they send the message. They also contact law enforcement to make contact with the alleged victim in the case. And what if it's somebody that just, at that point, because of the phone call, doesn't want to be found? That doesn't go to due diligence.
Your Honor, even at this point, we have not heard anything other than that they asked law enforcement to attempt to provide some sort of notice. We have not heard that law enforcement out there, law enforcement themselves made a call, that there's any attempt at searches. I think actually made efforts done.
Well, you're not arguing that a subpoena is necessary. I mean, if an officer went out there and say you have that, you're not making that argument, are you?
What I was saying is that at this point, we haven't heard that even an officer has made an effort. That is what I'm saying. I'm giving examples of what of due diligence and saying that this, at this point, we're going to be satisfied. Do you have some response with regard to the phone call itself? And I know previously in the matter I had with Ms. Grosso, she provided your time to call. I do not know if that occurred before this one. Mr. Gaddy from our office was at the previous hearing. And if you have not listened to it, I do wish to go through the phone call in more detail. But I wanted to start with that, in particular, having had a case where the victim advocate left a message on voicemail, and that was it. And with that.
Oh, that's a really good point. Yeah. Not looking good. Not looking good. Also, this argument coming from the defense attorney, when she starts getting called out on it, she doesn't know what to say. Same with the next case too. It's the same way. You come with a defense, you better be able to answer the judge's questions. And this is this Colin? No, this isn't Colin Anderson. Who is this? This is someone else that I know. Yeah, I can't. Someone help me with her name, please. Someone help me with her name.
There was definitely more in terms of that, plus the conversation where Your Honor found that it was not, that you did not find that it was my client's fault.
Yeah, but
So I want to start with that, but I also intend to address the information in the call.
Well, go ahead and address the information. I mean, Ms. Sender went through what the call was. If you want me to hear it, you want me to hear it. But I mean, if you're talking about the cases that I think you're talking about, I mean, what's said by the defendant in this case is got to be the most egregious that I've heard. I mean, it can go anywhere from just contact, all the way up to don't show up or some harm's going to come to you if you show up. I mean, on that spectrum, This call is way on that far end of the former of what I said, the latter of what I said.
Well, I think exactly what, if you listen to what their argument was, it was exactly that you take it piece by piece as opposed to taking the whole conversation in context. And in terms of the specific, well, as one example of the specific part of the phone call that was referenced, that, I think I need to get a PPO out of me. Your Honor, that was not part of the discussion or in, with regard to the part of the discussion involving if she should appear and that part of the phone call.
What do you do with don't show up, but if you show up, then tell them you made it up? Basically, I'm paraphrasing. What do you do with that, Ms. Gaines?
Your Honor, I think the first part is that even if that was what was said, if they have not gotten in touch with her about what the date was, if this phone call was dated weeks before, that is not in terms of what is required that the action actually caused the failure for the person to.
Okay, if you're gonna go harp on that, then what I'm gonna tell them is just 2 days before the preliminary examination, subpoena her. And then I can rule on the motion right now as to the conduct. And then if she doesn't appear, all of it's satisfied. On the 21st of this month. I mean, if the argument is being made that the people haven't done their due diligence, which I don't think is true, but if that's your argument that she needs to be subpoenaed, they can go through the efforts and try to subpoena it. They got 9 days to try to do that to get her here. And then if she doesn't show up, they're going to be able to proceed by forfeiture.
I would have additional arguments at that time, that the length of time since there's been any contact with her as to whether or not it's.
Because I had to shut off the phone.
I understand. I understand that.
I mean, that's the reason he hasn't had contact, and I can't even say that worked because.
Is there some information that you have that
I have a lot of information about a lot of things.
That is true, right? Let me ask a more pointed question. Let me ask a more pointed question. Is there information? Have you received information that there's?
Do you have phone calls from?
I don't remember who said it, but thank you so much. This is Joy Gaines. That's exactly right. Thank you so much for answering that question. Couldn't remember her name off the top of my head. I knew it wasn't Clena Anderson. She has a straighter haircut, I think. Yeah, her hair is straighter. Anyways, but yeah, thank you.
April 11th. April 11th till now. Then that means my order to restrict and revoke his privileges worked. So when you make the argument that there hasn't been any contact, it's because I had to revoke his privileges.
What you're saying. Still would want to address that if she did not hearing and was provided with the subpoena.
Address which issue?
The reason, whether or not he was the cause, his actions were the cause of her not attending. I do also though want to go back to the phone calls, that I do believe that there is a broader context to that the statements that were brought up about getting a PPO were not with regard to him having called her, and that these were, and they were not said in response to her, to him asking that she pardon me, let me say, him explaining that if she did not appear, that is how the case would look. I would also add that my client's statement of that the statement that's alleged to my client allegedly made my client that he indicated that she say something different, that alleged statement, that if he said that, our position would be that he was asking her to tell the truth about what happened. And that throughout the phone call, there are references to her being disrespectful of his mother, his grandmother's home, of behavior that he indicated to her prior to her calling law enforcement, and as he was asking her to leave his grandmother's home, was not what his grandmother or what would be found to be respectful of her in that home. And so there's a lot more in the conversation than simply those statements, and that there is a fuller context as to how, as to what was being said.
Does that context change the word?
For
I mean, that's what I'm saying, Ms. Gaines. I get your argument, but I don't know how you escape the words in this instance. I mean, go ahead.
In the case law, it indicates that the wrongdoing is the use of coercion, undue influence, or pressure to silence testimony that if would include threats of harm, suggestion of further retribution. There were no threats of harm or suggestions of further retribution made during that, or any retribution made during that phone call.
Anything additional?
Your Honor, if I may, just on that one note,
Yes.
the defendant was very cognizant that this was a recorded line. So whenever we got to the point of there being a potential for a threat or coercion or something that was explicit, he said, Casey, listen, we're on a recorded line. Casey, listen, don't do that. We're on a recorded line. That's enough in the people's mind to show that there is something in the background there. And specifically, the defendant says, are you trying to keep me locked up? And the victim says, no, like I want to put a PPO on you because I'm scared to death. I don't know what you're going to do to retaliate. The defendant responds, I'm not no crazy ass dude. And she says, I didn't think so either. And he says, so Casey, look, we on recorded lines, so can you stop talking like that? That makes me extremely uncomfortable, because to me that says that there's something more that needs to be said, and he can't say it because it's a recorded line and he knows that we're listening. That is threatening in the way that it's not, he's not able to articulate it because he knows it's going to get him in trouble.
All right, Caitlin Kirby Jr. is killing it. She really is. Every time I watch her, she's getting better and better. She is Caitlin Kirby Jr. I know they've all assembled, Birdie. I don't want to. I need to get better at timing with the music. And again, it's not finished yet. It's just a black screen, so I don't want to just, I'll still show it, but it's just not. It's not ready yet, so it doesn't work. It's just music. All right, there we go. Once that's better, and it's ready to go, I will do it on command, I promise. But it's just not ready yet, and it just doesn't. It doesn't flow yet, is what I'm saying.
Anything else? Ms. Gaines, anything else?
Just this, in terms of what the people just read to you of the statement, I think that how that conversation began, it did not give a response to a threat or don't come to court or else this will happen, do that, which is the point I was trying to make, to begin with, and that even if asking her not to talk about something is not the same as him refraining from making.
But at points during the conversation, he makes the statement about her not showing up. He also makes the statement that if you do show up, don't tell him what you said before. Don't tell him. I mean, he's basically saying to her, if I just were to put it in colloquial, don't show up. But if you got to show up, lie.
We would say that he did not tell her to lie. That what he was telling her is to not say what she said before, which was the lie. And that
He didn't say show up, tell the truth, did he? He was giving her the story.
Your Honor, he did not tell her specific words to say about what happened. No, but I will say he did not give her specific words about what she should say.
Court has reviewed, the pleadings court's listened to arguments on this case, and maybe this is the reason why the no contact certainly is put in place, because these particular things. As I read the comments made by the defendant in this case, one wants to give context to them. Some of them, you don't even need to have context. I mean, he's telling her what to do. I think there is a.
You're talking about the defendant, right? Not the defense attorney. Joy Gaines is not an idiot. I think you're talking about the defendant. The defendant is, yes, absolutely. But no, Joy Gaines generally does a really good job, and she tried hard there. She just was not ready for the judge to ask her questions. She wasn't.
Explicit and implicit as well as explicit threats to her regarding her testimony in the case, regarding her appearances. He is clearly, if anything else, in the confines of this conversation. I don't know why we don't have other charges. Obstructing justice, intimidating a witness. It's clear. And as I said before, this is probably one of the more egregious of cases. I'm not pretending to hear and see everything, but certainly this is egregious. So to the extent that you want to raise the issue of the due diligence on the part of the people between now and the time that the exam's set, they can do whatever they can do to try to get her here. If she's here that day, she can testify. If she's not, I am, given what I've seen at this point, allowing the people to proceed by forfeiture, and that her testimony will come in, or her hearsay statements will come in, that will be able to proceed along that fashion. All right, so the people's motion is granted.
All right. Now we're going to end on another Judge Simpson clip. I think this is, I know it's Judge Simpson. I think it kind of the same thing where the defendant was calling the the victim from jail. I feel like it's almost the exact same case, but just handled a completely different way, different defense attorney, still the same outcome. All right, let's go. And yep, again, if you guys all behave yourself, I will play a bonus clip. I've got a really good bonus clip for you. Really good. And I'm really excited about it. Otherwise, I wouldn't keep saying it, but I really want to play it tonight. I do. But it is going to be my release tomorrow. I'll talk more about that here a little bit.
Versus Michael Deshaun Kyle. Not yet. I have not signed a motion to withdraw.
This is Matthew Mansour, Assistant Public Defender with on behalf of Mr. Kyle.
I have this motion. Well, I have two things up because I have a motion regarding forfeiture. Ms. Ford, are you ready to argue that motion? Yes. Well, I've got a problem here because I'm trying to figure out what happened on the public defender side.
Your Honor, I can explain that. I was appointed to represent Mr. Kyle on this motion hearing today.
You mean assigned? Your office has been appointed from the get-go.
Yes, I was assigned to represent Mr. Kyle this motion today. I have sent a conflict check to our office this week.
What theme? What theme? Skizrock has a theme? I don't know what you're talking about. No idea what you're talking about.
Because of his new charge that he has picked up, the witness tampering charge, and while waiting for the conflict check to come back, either confirming that there is a conflict or not, I was prepping for this call. Just up until yesterday, our office has sent an email saying there is a conflict, please withdraw.
Takima LaShawn Cooper wasn't involved in the case before the other matter?
Takima Cooper is his mother, and she is a suspect in the new star.
So why would that cause you to withdraw in this case?
Your Honor, I don't handle whether it's...
Well, somebody needs to get here and tell me, because here's the problem. As of the 4th of April, there was no conflict. Right? It comes down I think it was the 23rd of April. Then his exam is set before me. There's then a request for an adjournment. No mention.
Heather does have a theme, but she's been sick lately. She's not here, so I'm waiting for her to show up for her theme. You guys want to hear it? I mean, why not, right? She has a theme. Oh, let's start it off strong. I need to clip a different part of that song, but this is Heather's theme. Well, there we go. There we go. You knew she had one, Johnny. Good call.
Conflict at that point.
Correct.
Then I don't get notification. So and then from that date, I adjourn his prelim. The people are going to file their motion. I give a date today for the hearing of the motion, and then the day before, I get a motion to withdraw, and by the way, no answer to the motion.
I completely understand the frustration from the court.
Oh, I don't think you do.
Your Honor, I was prepping for this matter up until yesterday. I'm just telling you where I'm at with it today. There was a conflict check that I sent this week. I was appointed to represent him today. I sent that conflict check this week. So
On the new matter.
on the new matter, and yes.
So since you're still counsel of record, what do you suppose I do with his exam?
This preliminary exam coming up on the 21st.
Yes.
Your Honor,
Skid Rocket, I can actually send you the name of the song if you want, and then you can add the entire song, not just the 30 seconds that I clipped out. Just so you know.
if it was up to me, I would request just a week adjournment to allow.
That's not the way the exams run. I understand that, but I've got a motion. They want to proceed by forfeiture. Who's going to argue that?
Your Honor, if I need to, oh.
Council told me what it was about, but I have not actually given those phone calls. So I will be overnight just.
Yeah, our office has jail calls, just separate.
Ms. Barroso, you've arisen.
Your Honor, the forfeiture motion is on the assault with the intent to cause great bodily harm less than murder by strangulation or something, not on the victim's intimidation. We do not need the victim to proceed on intimidation because it is based on the jail calls. All we need is the officer. I would say unless the public defender needs to withdraw from the original offense because of a conflict, that we proceed on a motion today, since he was prepping for it up through yesterday, and he responded orally on the record.
Is Tamika LaShawn Cooper a potential witness in this case?
She was not physically present at the scene, and it is my understanding, Your Honor, that the individual who the defendant called on the phone that was not 911 was the defendant's grandmother, not the defendant's mother. So she would not be a witness in any capacity in the assault GBH. She's just a potential co-defendant in the witness intimidation.
All right. First off, J Fire, thank you so much. Sitting in the late chair, Jedi caught me. You're fine. Yeah, Jedi will bust out her lightsaber on you. She will. Be careful with her. But I appreciate you here, and thank you so much for the super chat. Very generous of you. Thank you. Also, I know there's a sign that says all these calls are recorded. Why are we still getting phone calls? What is going on? There's something crazy going on outside. I just heard like an engine revving. Anyways, lost my train of thought. Oh yeah, all these two cases that both have to do with jail calls. Why? Just stop.
We have not brought charges against her in that case.
How do I have a motion that tells me that this is a witness in this case? And I just heard she's not a witness in this case. She's not even a potential witness in this case. That was the question.
Your Honor,
You need to, you know what, Mr. Mansour, I realize how that process works. So what I'm gonna ask the jail to do is to take him back. You find somebody that can give me an answer to that. Now. Take him back. Yeah, court stands in recess. But in the case of the people of the state of Michigan versus Michael Kyle.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
So that we've had a bench conference in this case, so that we're clear, and I think the court is correct, and it's just been said, the court is not going to sign or allow the withdrawal of the public defender in this case. Ms. Ford, so the public defender is still on this case. Did you receive two requests for assignments on Mr. Kyle? I was talking to before. That's okay. I'll explain what I mean. What are the last four digits of your case number? 1225. That's the other one. 2. Got it.
I got something that said I should be here today.
Right. Partially because they had sent in the motion to withdraw on this case that's up today, which is the one ending in 1212. Right. But I'm not permitting the public defender to withdraw because there is no conflict. Somehow there was some confusion. There will, I guess, potentially be a conflict tangentially, but I'm not going to get into that. But on the other case that Mr. Kyle has.
1225.
1225. Have they made you aware that 1225 is set for preliminary examination on the 21st? Okay. All right. So if you know that, I don't know if you have discovery, they're going to make sure discovery and all of the phone calls and everything get to you, Ms. Barroso, when we were at the bench, where she's going to make sure that happens. Is that correct, Ms. Barroso?
That is correct. I was writing down her email address for me so I can make sure you get that to her. I should be here on the 21st.
Yes.
And are you going to hold the hearing today on the other one?
Yes. All right. Very good. All right, I've read now back to the case 1212. I've read the people's motion. There is no written response from the defendant, but you can go ahead, Mr. Mansour. Did you wish to respond to their motion to admit statements?
Your Honor, could I ask?
Yeah, this guy's not ready. This guy was not ready for this hearing at all. And I mean, I'm not an attorney. I don't know how it works. He walked up and he thought that this was going to be adjourned. It wasn't. But I mean, you have to be ready, right? You can't just ask for an adjournment and expect an adjournment. You still have to be ready to defend your client because an adjournment isn't guaranteed. So this is I don't know. If I was the defendant at this point, I would ask for what is it? Why can't I never think of words? I need to stop streaming so late. Maybe I'll start streaming at 1:00 instead of 8, and I'll be able to remember words. When your defense counsel isn't, working their best. I can't think of the term. Anyways, let's see. There's still like 10 minutes left of this video. I thought it was almost over. It's not even close.
This will also for a copy of this.
No. This case right now happened yesterday. The case I played before was last week. It's not the same day. It's not the same defendant either, but it's very, very similar cases.
The motion.
Thank you, Aaron. That's what I was looking for.
Personal copy, do you need it?
Well, hold on, counsel. So, Mr. Mansour, because of the withdrawal, which may not have been the proper withdrawal, you're not prepared to argue the motion. Would that be a fair statement?
Your Honor, I would like to have additional time to be able to prepare. So
I think my question is a yes or no.
So, to answer that question, not 100%, but I can do my best.
Mr. Kyle, I'll let them explain to you what happened. All I know is we had set this, and I'm sure you recall you were here before me on that date, and I gave a motion date. People were supposed to have everything in, and that was going to be today, and then you have your exam set later in May on the 21st. What's happened, and I'll just explain it I'll let everybody else fill in the details, okay? But I'll just say, yesterday I received a motion for the public defender's office to withdraw on this case, right? My understanding is it was only supposed to be relative to your other case. Got it? So, from what I'm understanding from what Mr. Mansour said on the record earlier, that he's preparing to handle this motion that I have set for today, but then once he's apprised and he doesn't make that decision that there's a conflict, he stops. While he's willing to argue it, I don't know that he's had the time to thoroughly go through it because he had to stop. Okay. Today's the 9th, right?
Yes.
I don't even remember anymore. I really don't. No idea. This is a violation hearing because he was calling the victim's like not talking to her directly. Was he? I don't remember at this point. I'm just ready for the bonus clip. To be honest, I'm already moved on from this clip.
That is. Everyone. Okay, to try to salvage this and not jeopardize, most importantly, the people's right as well as your rights, Mr. Kyle. I'm going to do it this way. Timing won't be ideal, but I'm going to adjourn the hearing on the motion for forfeiture to the 14th in the afternoon. All right. Folks, the people here should, I think, be here I'm gonna go in the afternoon because you should be here on prelims in any event. So I'm trying to pick that date that causes. I'll be here anyway, so, and you ain't going anywhere, so you'll be here, okay? So that's what I'm gonna do. You understand that, sir? All right, you have any questions about it for me? Okay, all right, that's what I'm gonna do. So I'm gonna adjourn the motion. Your exam, which is really the most important part of this because it's already been adjourned, I'm keeping that on the 21st. Okay, I'm just taking this motion we were supposed to hear today, giving a few more days, let them get caught up, and then I'll hear it on the 14th. Fair enough? Yes, at 1 o'clock. All right.
Is it okay for me to talk to him? Is it basically his exam on?
Today? Well, they've got to get him back down. So, I mean, because I'm holding the jail up. What's wrong?
Right here or is it?
All right, we're gonna move on to the bonus clip. You got what? Yeah, I have no idea what just happened. Anyways, so you guys ready for a bonus clip? Who's ready for a bonus clip? Also, Fozzie is in the house. Good to see you, bud. Good to see you. I'm so glad you're here, man. Haven't seen you in a while. All right, let's find this bonus clip. Do. And here we go. All right, you guys know all the rules for my bonus clips. They are releases that I'm going to release tomorrow, but because you're here live, you get a little sneak peek. All I ask is you jump on the video and hit the like button on it. I would appreciate that. You don't have to rewatch it again, but I would absolutely appreciate it if you would just jump on and hit the like button. But this one's good. This one's good. You guys ever wonder, what the punishment is for someone running on a baseball field or a professional stadium? Let's go. What's going on? How's everyone doing?
Anyway, tell Colin. I'm ready.
I'm interested in. I'm interested in knowing what possessed him to do something like that. Is that what you want to do, Mr. Orlowski?
What is it? Sorry.
You want to plead guilty today?
Yes.
All right, can you raise your right hand, please? You swear or affirm to tell the truth, the whole truth?
Yes, Fozzie changed his name, and I'm guessing he didn't understand that he couldn't change it right back. He changed it, and he can't change it back. So Sarah, Texas is Fozzie. That is Fozzie. Dwight Turner. Is it too early for boss? Like, you nailed it, though. I paused it right at the right time. But yeah, so what we have here is a defendant who ran onto a baseball field. But I've got a very interesting twist in this. I think you guys are going to enjoy it. Let's go.
Nothing but the truth.
Yes, sir.
You can put your hands down. You understand the maximum possible penalty for this offense is 93 days? No, strike that. 90 days in jail and or $500 in fines?
Yes, sir.
You understand you have an absolute right to a trial?
Yes, sir.
Mr. Berry went over your other advice or rights in the breakout room, did he not? Did he not?
He did.
You understood those rights?
Yes, sir.
You have any questions about those rights?
No, sir.
No, by taking this deal, you're gonna give those rights up?
Yes, sir.
Has anybody offered you anything other than what's been stated in the record?
No, sir.
Let me draw your attention back to August the 9th, 2023 at around 7:35 p.m. in the city of Detroit in the area of 2100 Woodward Avenue. Were you around that date, in that area around that date and time?
Yes, sir.
And what's over in that area?
There's a Tiger Stadium.
America Park?
Yes, sir.
Yup, this is the twist. I actually found the footage of him running on the field. It's good. It's good. Let's go. Look at what he's wearing. I saw a close-up picture of it in the article I found this clip of. All I did was typed in the date and Tiger Stadium runner. That's all I did, and I found the article about this guy, which is how I confirmed it was him. But he wore short shorts and a bright yellow shirt to a Tigers game when he's clearly a Tigers fan. So, yeah, this wasn't a last-minute decision. He went to this game planning this.
And you were in the stadium at that date and time, correct?
Yes, sir.
And is it true that you jumped over the fence and ran across the playing field during the game?
Yes, sir.
What would possess you to do something like that?
Well, well,
Say
at
that
the
again.
time, yeah, at the time I was trying to impress my friends and I was not in the right state of mind, clearly. I know that it affected a lot of people and that were there, and I really apologize for that. Since then, I've been getting closer to God.
Sounds like you've been getting a lot closer to your wall. I know people are bringing up the walls, and I was really hoping Judge Perkins would do it as well. I mean, come on, man. I can't tell. This kind of looks like it might be, he's 20. This might be his parents' house. I don't know, but the walls, really, really, man. I punched one hole in a wall in my entire life. In my entire life once. And I had to learn how to replace drywall because of it. Yeah. Yeah. Just saying. Don't do it. Don't do it.
I have a job. I'm going to college. I really have changed my life around, I feel like, because at that time, clearly that's not something that should even happen. It's just interfering with a game, and then it's wasting people's time as well. Think that it just is just terrible that it happened, and I know that it won't happen again. Yeah.
How old are you, sir?
I'm 20 years old.
And when you say to the court that you weren't essentially, I may be paraphrasing a little bit, about in your right mind, what state of mind were you in?
Oh, just pure stupidity and acting like an idiot. I don't know.
Did anything outside forces contribute to that?
What do you mean by that, sorry?
Was there any kind of mind-altering substances that you took or anything that day?
No, sir.
No alcohol involved?
No, sir.
All right, right now I need that. You guys have all seen it from whatever social media platform you watch, but that one kid just being like, bullshit. Bullshit. Yeah, that dude was drinking. 19 at a baseball game. I mean, you weren't buying it there. I mean, maybe, but Smart answer is to tell the judge no, but guy was drinking. The guy was drinking.
Just a prank, huh?
Basically, yeah. It's not too funny of a prank.
Find your client guilty as charged to the disorderly conduct. You said you're satisfied, Counselor?
Satisfied, Your Honor.
I'm gonna fine him $240. I'll take it under a 6-month delayed sentence. And I'm gonna have you pay it in a month, though.
Okay.
Come back on June the 14th at 8:25, I'm sorry. Pay that in a month, 6-month delay, pay it, and then he did that kiosk in the city of Detroit, or come on down to the courthouse and pay it in person. I'm told you can upload that.
All right. There's about a minute left of the bonus clip. There you go. When you run onto a field, $240 fine, probably spend a night in jail, and he's trespassed. He can no longer go back to the Tiger Stadium. And he looks like a fan too. If you look at his room, it's all decked out in Michigan stuff. He's got a little sticker on his wall of a Detroit Tigers player. I can't tell which player it is though. But that's what's gonna hurt him more. He's trespassed from the stadium. Now, if he just goes and buys a ticket and just walks in, they're not gonna know who he is. But if he tries to buy one online, it's gonna be checked. All right. That's all I got. Let's go hang out on Discord. Oh, we're gonna. I think Court Vibes is going on. We're gonna raid Court Vibes, not Court Vibes. Fred's here, and I'm thinking Court Vibes. We're KCC. KCC is who we're raiding. All right, we're raiding KCC. All right, you guys all have a great night. I'm gonna raid KCC. Jump in there and say hi, and let's hang out on Discord shortly after that. You guys are all awesome. Thank you for the super chats, the membership milestones. And I will see you all tomorrow. And yeah, bonus clip. The bonus clip rules. You have to jump on the video and at least hit the like button. For me, please. Please. All right. Until next time. Bye.
Dip that out to your phone. Those are the two best ways I can tell you to pay it. And then we'll proceed to see where it goes on June the 14th. All right.
Okay. And do I just call the number that's on this card to pay it? Or do I have to come in?
I would pay it at any DivDat kiosk. I'm sure you can pay it over the phone, and you can probably do that and probably have enough time to get here. But the kiosk I know comes in immediately, and you can find those in the Myers, CVS's, and things like that. And I'm told you can upload the DivDat app to your phone. So with those, you can pay it online too. You know, it's a 6-month delay. So pay that is the best way you know, but those are the two best ways I can tell you to pay it. All right.
Okay. Thank you.
Nothing further, sir. Have a very good day. Best of luck to you. All right.
Yep. You as well.
Thanks.
Bye.